How do you pay personal representatives and trustees? Hi, my name is Alec Osland, and I'm an attorney at the Yanowitz Law Firm, where we've been assisting families and loved ones with wills, trusts, and probate for over 3 decades. Serving as a personal representative or trustee after a loved one passed away can be a difficult and time-consuming job. Therefore, I get this question a lot of, can this person be paid? The answer is generally yes, as we normally draft language into our documents that allow either the personal representative or the trustee to be paid a reasonable fee for their work. Well, what is reasonable and what does that look like? And I always give the famous attorney answer that everyone hates. Well, it depends. Essentially, the personal representative or trustee, they can keep track of the amount of time that they spend acting in that capacity. We generally say a reasonable fee is around $30 an hour. Now, that being said, if your personal representative or trustee is a CPA for their day job, and if they're acting in that capacity, well, then they can charge, the normal fee that they would charge while acting in that capacity. But if they're just cleaning out the house or mowing the grass or organizing some things, they generally they're not going to be allowed to, charge that higher fee that they would be if they were acting as an accountant on behalf of the estate or the trust. So all of that being said, when the personal representative or the trustee is paid, that is considered income, and they will have to claim that on their income tax return the next year. So essentially, these payments are taxable. So what a lot of my clients do instead is they may leave a nominal amount of money to the person who is going to be acting as personal representative or trustee. Let's pretend we have our friend Bob, who's going to be a trustee when you die. So essentially, we may set up a gift that says something along the lines of, upon my death, I leave $5,000 to Bob. If Bob predeceases me, then that gift is going to lapse. This would allow Bob to get this $5,000 gift, and it'd be an inheritance, and therefore he wouldn't have to claim it as income on his taxes. It is very important that we do not make it a requirement that Bob has to serve as trustee to get that gift. If we had said something along the lines of, upon my death, I leave $5,000 to Bob if he's willing to serve as my trustee. If we had done that, then that would make the inheritance a condition of employment, and therefore he would have to claim that on his taxes. So essentially, we are relying on the person who we want to serve, agreeing to serve when we are passed away. So it's a good idea to make sure that person who you want to either be your personal representative or trustee is going to be willing to act as that person when you pass away. Compensation for personal representatives and trustees is important, as there is quite a bit of work that they may have to do. Therefore, you want to make sure that the applicable language is in your estate planning documents so that there's no issues with them getting paid for the time that it takes to administer everything accordingly. If you're interested in learning more about estate planning, make sure you subscribe to our YouTube channel to find out when we post another video. Thanks, and have a great day.